Hi everyone, welcome back to our channel. I'm Chelsea Kennedy, the Executive Practice Coordinator here at Butler Wills & Estates. In our last video about the differences between probate and administration, we mentioned that one of the documents needed for an administration application is a bond. This video will look at bonding in more detail, including what the options are for getting a bond, what to do with the bond, and how to end the bond when it's no longer needed. Let's start with why a bond is required. As we mentioned, bonds are required for administration applications only. They are not needed for probate. Having an administration bond provides the court with some assurance that the value of the estate can be recovered if the administrator acts negligently. It's like having an insurance policy. It may not be needed, but it's there just in case. There are two options for obtaining a bond. First, the person applying for administration can purchase a bond from an insurance company, or the applicant can select two sureties to sign on his or her behalf. Let's look at each option in more detail. An administration bond is purchased from an insurance company. The applicant provides the company with information about the estate, such as who passed away, the value of the estate, and what kind of assets are in the estate. The applicant also provides information about his or her own finances, including a summary of their assets and liabilities. This information is used by the company to determine how risky the bond is. As with insurance policies, the company will charge an annual premium for the bond. The amount of this premium is determined by the value of the estate and the company's internal rates. If the applicant resides in a jurisdiction with multiple options for bonding companies, it can be worth it to get estimates from more than one place. When purchasing a bond, the company will most likely require payment upfront. The company may charge multiple years' premiums at the beginning. If some of the subsequent years are not needed, the premium for those years may be refundable. The second option for obtaining an administration bond is to have two sureties sign a bond on the applicant's behalf. This bond is prepared by a lawyer rather than by an insurance company. By signing the bond, the two sureties agree to pay the just debts of the estate up to the total value of the estate if the administrator is negligent. This means that if the administrator takes the money in the estate, the two sureties will be responsible for the debts in the estate. The sureties can be any adult who reside in the jurisdiction where the estate is located. Often, applicants choose their spouse or child. As part of signing the document, the two sureties swear an affidavit that says that they are over the age of majority, that each person is willing to pay the debts of the estate if necessary, and that each surety has assets of at least the value of the estate. For this option, there is no upfront fee. The sureties would only be responsible for paying anything if the administrator does not handle the estate properly. The bond, whether it is purchased or has two sureties, is filed at the court along with the rest of the application for administration. The court keeps the bond as it is part of the original application. There is an alternative to obtaining an administration bond, but it's not accepted in all jurisdictions. To avoid getting a bond, an additional document called an Affidavit to dispense with filing an administration bond, pictured here, is included with the application. This affidavit tells the court that the applicant is familiar with the deceased financial situation, including assets and liabilities, and that there are no significant debts. If there are no debts, the court doesn't need to worry that the debts won't get paid. As we noted, this option is not available in all jurisdictions. For example, in Newfoundland and Labrador, the court will only waive the bond requirement if the public trustee's office is being appointed as the administrator, since they're a government office. The bond ends when the estate is completed. This means that all of the taxes and debts have been paid and the beneficiaries have received their shares. For either type of bond, a release from the courts is sufficient to end the contract created by the bond. To be released by the courts, the administrator needs to appear in front of a judge and show the court his or her accounting, including a summary of receipts and disbursements. This is an expensive and time-consuming option, which is usually only used when there is an issue in the estate, such as a disagreement between the administrator and beneficiaries. For a bond with two sureties, a release signed by the beneficiaries is usually sufficient to end the bond. It's also a good idea to obtain a tax clearance certificate from Canada Revenue Agency, which states that all of the estate taxes have been paid in full. To end a bond purchased from an insurance company, it's sometimes required that the original bond be returned. This isn't possible in all jurisdictions, as the court doesn't often return filed documents. The issuing company may accept a release by heir in lieu of the original bond. This is a sworn document that says that the beneficiary has received everything they were supposed to and won't hold the insurance company liable in the future. For more information about administration bonds, visit our website, butlerwillsandestates.com, where you can find resources, including podcasts, quizzes, and downloadable forms, all for free. Also, send us an email to request a free brochure about administration bonds. Don't forget to visit Lynn's blog, estatelawcanada.blogspot.ca, for a ton of articles about estate law. See the description below for links. Where to find us. Check out our website, www.butlerwillsandestates.com, or send me an email directly at chelsea@butlerwillsandestates.com, or call us at 709-221-5511. If you liked this video, make sure to click the like button, and if you want to see more videos about a variety of estate law topics, make sure you click the subscribe button. Thanks for watching, and we'll see you at our next video.